The Court of Appeals is now in session.
Good morning and welcome to the Court of Appeals today, the virtual Court of Appeals. We are preparing to hear oral arguments in several cases this morning, the first of which is in the matter of the adoption of E.M.F and M.F. And counsel, if you would please enter your appearances for the record.
Jason Richards, good morning for the appellant and petitioners in this case.
Good morning, Your Honor. Sarah Frommer of the Appellate Group for the Appellee. And I apologize for my technical problem. I don't know what is going on. But
that is absolutely no problem at all. Understandably, sometimes we have technical issues. The court sometimes have technical issues, and that is really the only thing. I know both of you have appeared in front of the virtual Court of Appeals many times, and the only warning, I guess, or instruction that I would give you is that if you have technical issues, if you can't hear, if you can't see, if somehow the clock stops working, let's just make sure we all keep in touch with each other, and if you could notify us as soon as you possibly can that there's a problem, and we'll get it fixed, and then we'll go from there. The other instruction I would give you is that while you are presenting your arguments, please obviously keep your camera on, and we'd like to see your faces. The judges, if they have a question, will keep ourselves mute while you are arguing for better connection. And if we have a question, we'll either raise our hand or somehow try and get your attention. And then if the lawyer who's not arguing could please turn their camera off and mute their microphone, that will see. It's the problem with being a lawyer. I think I cannot say mute. I have to say moot. So if you could mute your microphone while your colleague is answering questions and presenting their argument, that would be helpful. Do either of you have any questions before we go forward? Doesn't look like it. Then Mr. Richards, please begin when you're ready.
Hey, thank you. Good morning. I appreciate this opportunity. The main issue that we have in this case is the failure of the trial court, in this case a district court, to properly assess an abandonment claim under the Termination of Parental Rights Act. That is the primary issue today. Rule 52 requires the trial court to enter findings of fact and conclusions of law specifically related to the claim that is being brought before it. In this case, the main issue is the conclusions of law that were reached by the trial court. It's an interesting procedural posture in that the trial court did an involuntary dismissal at the close of the petitioner's evidence, which essentially is that he found that the petitioners did not establish a prima facie case of an abandonment claim. But our essential argument on appeal is that the trial court did not enter conclusions of law consistent with an abandonment claim. Now, there are no written findings in this case. It was all done orally, which is permissible, but even the oral findings are insufficient. Whenever this court reviews conclusions of law reached by the trial court, it is a correctness standard. And so this court does not have to give the trial court any sort of deference in its conclusions of law. Now, the Termination of Parental Rights Act outlines what evidence needs to be established for an abandonment claim. And this whole section of the Juvenile Court Act is recodified as of tomorrow. So if I were arguing this tomorrow, I'd have to cite an entirely different statute. So I'm going to refer to the one I'm more familiar with and the one that certainly was in effect at this time. I don't think it's
Mr. Richards, can I just interrupt you? I understand that I want you to get to the merits of your claim about the adequacy and the correctness of the court's findings. But could you please address the jurisdictional question? If this court doesn't have jurisdiction, then we can't even get to that discussion. And so, can you help us out and explain to us why we do have jurisdiction to entertain your appeal?
Sure. So the appeal was taken from a final order that was issued in June. I mean, that's issued in our reply. We addressed that issue. But there's a number of different things that are problematic, I think, with the argument that the 150-day rule precludes the notice of appeal that was issued in this case. Number one, it was the father who was preparing this final order. It was the father who wanted this written order, and he spent a year and a half obtaining it. And so he was the one that submitted the order. He was the one that prepared it and drafted it. There was over 6 months of argument over what will be in the order, and eventually the trial court issued the order. So number one, I think there's a preservation issue, and this has never been flushed out by case law. So there's really nothing that we have to go off of. But the father to then turn around and argue on appeal that order is meaningless, that order has no meaning, I think he waived that argument by presenting that order.
But can a party waive jurisdiction? If our court doesn't have it, can a party somehow manufacture it or waive an objection to it? Well,
again, and I don't think that this hasn't been addressed before, but I do think that if the party is, well, and it's a preservation issue as well, so maybe it's not necessarily a waiver, but if an order would have been prepared by my clients and submitted to the trial judge, and then the father comes in and says, hey, it's been 150 days now, this issue is moot. It can't be, the court cannot issue a written order because it's been 150 days, the oral findings are sufficient, we're done. Then the trial court has an opportunity to rule on that issue. That didn't happen here. And so,
but why, when the 150 days hit, why was the case not final then and the time for filing the appeal triggered? Because otherwise, what you're saying here is that a party who wins below could delay an appeal forever, right? They could just be down in the court messing around, saying, well, I'm preparing some findings. I mean, the rule says if at 150 days nothing's been entered, then the case is deemed final. So I'm just trying to understand why at that point, regardless of what father was doing, why was the case not final at that point?
Well, there's a number, well, I've addressed the preservation issue, but I don't think it was final because there was the father was clearly preparing a written order. And so, you get in March of 2019, and this is addressed in our brief, and that's before the 150-day deadline. The father submits a motion to the court saying, I'm preparing written findings, I need the transcripts. And so that puts my clients on notice that there will be written findings issued despite what the judge said during the hearing. The other issue too is that the 150-day rule is adopted from the federal rules. I mean, clearly the Utah Civil Procedure Drafting Committee looked at the federal rules and just adopted that 150-day rule because, and we go through some of the history in the reply brief and then back to the motion, but the rule was adopted in the federal court because the federal court was tired of waiting for attorneys to prepare orders, right? And that's what our rules say. Our rules has the prevailing party to prepare orders. And so when that rule gets adopted, that similar rule was not amended. The Utah rules are the same, but we now adopt the 150-day rule imposed by the federal court. So the main issue that I think is problematic with that argument is the noticing provision, because it's not just 150 days. It's specifically 150 days from when the clerk notes the decision in the docket. That's what the rule is, because that's what happens in federal court, and they just adopted the same language. The problem is the federal court, the entire system for entering orders in the federal scheme and the state scheme is different. It's completely different. In federal court, especially now, and I found this hard to put in the brief, and so it's easier to say it.
I'm not sure why that matters, though. I mean, if looking at the plain language of the rule, it doesn't say anything about that. I mean, it just seems fairly straightforward under E2B. If a separate document is required, a judgment is complete and is entered at the earlier of these events, and then it says 150 days. And so why isn't the simple answer here just when we get to 150 days, that's it, it's now final?
Well, it's 150 days from when the clerk enters the decision.
Well, it's
That's
from
what it
when
says.
the clerk records the decision, which I think everyone understands happens in a minute entry the day of the decision. And that's what happened here, right? The clerk entered this in a minute entry on the very day the court rendered his decision. It's not as though this is some kind of, surprise to anyone. I mean, this is how decisions are entered here. And it would be very unusual for someone to not understand that that would be entered immediately after the decision is rendered. And it's 150 days. It's 5 months. It's not as though there's this gotcha in there where, you have 3 days. You better be paying attention. I mean, we're talking about 5 months here. So I'm just trying to figure out why it is that your client doesn't have adequate notice.
It's the noticing provision. I mean, that's our position, is that the clerk enters in a minute entry, but that minute entry is then not passed on to the parties. I mean, yeah, we can all assume that's when it's finalized. We all know that's when the clerk enters.
So you're saying a minute entry doesn't qualify under that rule?
I don't think it does in this case because there's no evidence that that minute entry was ever noticed or given to anybody.
So if a minute entry doesn't qualify under that rule, what would that language under E2B mean? Because the language is the clerk recording the decision however designated. So
Well,
if that doesn't refer to a minute entry, what would it be referring to?
It refers to a minute entry. I mean, it does for sure. I guess what I'm saying, and this is fleshed out in our reply, is that the rule as written and as applied is unconstitutional because it doesn't provide notice. In a federal case, when a minute entry decision is reached, it's entered on the docket. The docket is e-filed and it's noticed to everybody. In a case like this, it's not noticed to everybody, especially in an adoption case when by statute, as soon as the case is over, the case is sealed. So there is no access to it. My clients, and this is what the father had a problem accessing the trial transcript. You can't just pop down to the courthouse and ask to look at the minute entry of an adoption case.
Even if you're a party or an attorney, you can't? If you make an appearance in the case, you can't ask for access to the docket?
I can't, no, I can't. Like in an adoption case, whether it's successful or not, the case is sealed by statute at the end of the case. I can't just show up and ask. I have to file a motion to reopen the case so that I can get copies of documents. That's what happened in this case. That's why we had a difficult time getting transcripts. We had to file a motion to unseal the transcript so it could be provided.
Which certainly suggested to you that the case was over. Yeah. I mean, if no one can access it, everyone pretty much knows it's done, right?
Well, in this case specifically, at the time that the clerk prepared the minute entry, the court signed it, and that minute entry signed by the court was not a private document. It wasn't entered on the docket as a private document, unlike some of the other documents in this case. But that's neither here nor there because it was sealed after it was over, right?
Right. It usually orders you can access, but in adoption cases, it's sealed. You can't access it. And so that's
even the minute entries. Just to make sure I've got this right. You're saying even the minute entries your client didn't have access to?
No, I didn't see that minute entry until I got the record on appeal. It was not in any of my client's very legally sophisticated. She's a paralegal. She had a whole copy of her file, but that minute entry was not there. And I didn't do the case in the trial court. She had different counsel for the trial, but the file I inherited didn't have that.
Can I just ask one more sort of policy question? I mean, certainly the notice issues and the due process issues in applying the rule to adoption cases or cases where access to the record is much harder. But would it be the same? Would you feel the same way and have the same argument about a case that was just a normal civil case where pretty much anybody could go and get a copy of the docket? Are the concerns that you have, the constitutional concerns, would they be the same for just any other random regular case?
The concern, I think, is there, and if an order is entered or a minute entry is ordered in a typical civil case, and again, I'm just speaking from my experience, but I think that is with policy, is that when an order is submitted or a minute entry is submitted, I get an email from the court saying something's been submitted on this case. The e-filing system doesn't send me a copy of it, but I get notification of it. In a case like this, that doesn't happen because the case gets sealed. And I'll also mention in juvenile court, where you're dealing with these cases most of the time, you don't get automatic notice from the juvenile court's e-filing system. And so if something is done like that, if the juvenile court judge in a termination case makes an oral ruling, oral findings, and the clerk enters that minute entry, it's in the system and it's sealed. You can't act, you can maybe go and find it if you ferret it out in a non-adoption case. So if it's a typical juvenile case, but notice isn't given unless it's emailed by the clerk. And that's what I'm saying here is there's no notification that the clerk or the court ever sent this out to the parties.
I recognize you have a blinking light. Can we spend just a minute or two on the merits of this? Let's move past the jurisdiction. Let's just assume jurisdiction for a minute. Would you agree, for purposes of the abandonment analysis, that it matters whether the custodial parent made it more difficult for the other parent to maintain contact with the children? Do you agree that matters, or do you think that just doesn't matter at all?
Well, I think it matters, but I think that the weight that you give to that occurrence, and I think the record is mixed on that issue in this case. But I think
before getting to this case, I just want to pin you down a little bit, if I could, legally. So you'd agree legally it could matter? I
think it matters in the second part of the abandonment analysis. The initial analysis is on, has there been 6 months of no contact or more? That's it. And there is specific case law on that, where where this court and the Supreme Court had a similar case where a father had a protective order against him. I mean, he legally could not see his children, but it still satisfied the abandonment claim because he had no contact, no communication with his children. It's not enough to just communicate with the custodial parent to attempt to arrange contact. There has to be contact. So for the first...
that would be true if I understand the law correctly, if we're dealing with the prima facie analysis. But if we accept the respondent's contention that what the judge was really doing was moving into sort of a judgment on the merits, that wouldn't be true. Do I have that right?
You mean, is it relevant?
Right. The 6 month analysis is relevant to the prima facie component of it, but not if he was really just ruling on the case as a whole. Or am I wrong on that?
I don't think that's right, respectfully. I mean, I do.
Yeah. I want to make sure I've got this right.
So I think that, the first prong, 6 months no communication, prima facie abandonment. Second, the respondent parent has to show that he has not willfully disregarded his obligations to the child, and that's where the father can present evidence to the contrary. And so, but it's more than that. It's also that it hasn't eroded the relationship between the child. And I'm probably butchering the second prong of that analysis, but that's essentially what it is. And so while it is relevant to some extent, that if there is evidence that the custodial parent has limited access, I think that's relevant to some extent, but we never really get there because
okay, so even taking it on those terms, moving into this case, would you at least agree that if mother is moving around a lot, that would make it more difficult for father to maintain contact? And if so, would you at least agree that that would have some bearing on the ultimate abandonment analysis?
Well, the findings don't support that conclusion reached by the trial judge, frankly. But I mean, he says
Which part? I mean, she is moving around.
The moving, because it's during those periods of moving, which is like 2 years, right? It's about 2.5 years that there's been several moves, but the evidence provided was that the father knew exactly where she was. He had access to her address, and his excuse for not pushing and filing, say, a custody action was that he thought he had an agreement with the mother about contact. That was during the move, so it's not like she was moving and not having contact with him. All of the contact between the parties occurred during that 2.5-year period. So no, I don't think that's what the evidence showed. I mean, that's certainly what the judge found at the end of the case, but that was not supported by the weight of the evidence. The evidence was that during those moves, that is when the father said, I didn't file a custody action because I thought we had an agreement on contact. An agreement that is nowhere in the record, by the way. Sorry, I don't know if I should continue or...
Let me ask a question. One of the issues raised in the red brief was an alternative grounds to affirm, arguing that the mother and step-parent did not demonstrate that a termination of father's rights here was strictly necessary. And unless I missed it, I didn't see any reply to that in your gray brief. Is that right, or am I just missing where you responded to that?
No, the issue for me on that, well, and whenever you're doing a reply brief, you're so limited. I had to focus on, what issues I thought was most pertinent. The court never got to the strictly necessary because it never got past the grounds factor. The trial court didn't find grounds to terminate, and so it didn't even get to best interests, which is part of the strictly necessary analysis. I mean, strictly necessary is wrapped up in the best interest argument. We didn't even get there.
So your argument is if we were to reverse here, the court would still need to do the best interest and strictly necessary determinations, and we should allow the court to do that rather than decide on the record on our own that component, that prong hasn't been met.
This isn't a case, frankly, that I think the court could just remand with an order to terminate. Because the trial court didn't even get there. I mean, didn't even get to the best interest prong. So I think if your honors remand the case, I think a new trial has to be held on those issues, especially.
Okay.
Okay. Well, barring any other questions, I'll go off camera.
You're like, as quick as I can, I'm going to go off camera.
No, I'm good. I like it.
Thank you, Mr. Richards. Ms. Frommer.
Okay, am I back? Okay. Again, Sarah Frommer for the Appellate Group, representing the appellee, the father, and the biological father in this case. I'd like to start off with the jurisdictional issue because, as the court recognizes, the jurisdiction of the court is a threshold issue that dictates whether the court even can hear the merits of the issue. I remember quite clearly back in 2013 when this first came to the attention of the Supreme Court and when they issued the decision in the United Water Conservancy versus King case where they said...
Can I just interrupt 1 second? Our clock's not running. So just get that going, and then sorry about that interruption. Go ahead.
Okay, are we better? Are we? All right. So in 2013, the Supreme Court specifically asked the Rules Committee to address the issue that very much concerned the Supreme Court in that case of the Utah Water Conservancy versus King, of the endlessly hanging appeal period. And I remember this so quite clearly because at that particular point in time, I was involved in another case where we simply could not get the court to issue a final order. And we were the ones who lost, and we were the ones who wanted to appeal. So I followed the whole process with great interest. And there's no question, based on the rule, the actual provisions of the Rule 58A-E2 and the committee notes with respect to that, that the reason for putting the 150 days in was precisely to protect against the appellate, the appeal to the period to file an appeal to extend.
Does it matter whether the party got notice of the minute entry?
Well, I think that, well, first of all, let me back up a second. In the Supreme Court decision of Criven versus Christensen, Snow Christensen, Martineau, they specifically talk about how the rule, both the Rule 58A, should be applied mechanically, and that it's intended to be a bright line rule.
So your
Rule
position would be that even if the party did not get notice, that the 150-day rule would still apply?
Rule 58A, Rule 58E2B says nothing about notice. It says recorded on the docket. And it doesn't say even what they should have notice of. There is no question that all of the parties to the trial, who were there at the trial, who heard the judge announce his decision from the bench and announce at the end of that decision, I'm done, these are my findings, I'm not preparing an order. If you want an order, you prepare the order.
But pushing back on that, E2B hinges the date off of when the clerk designated the order, not the oral findings. And so
it says when the clerk
recording the decision,
right, however designated. And as Judge Pullman pointed out earlier, there's no doubt that the clerk recorded the decision. They entered a minute order. This rule says nothing about notice. Now, if there was a situation where an order was entered and nobody knew that there had been any sort of final decision or had any reason to expect that there had been any sort of final decision, maybe then you have a lack of notice problem. But in this case, everybody knew that the judge had rendered his final decision. He was not going to do anything further. And that decision was, in fact, entered.
So let me ask you about that more pointedly. Is he right that given the adoption posture of this case, the parties were not given notice of the minute entry? Is that correct, or is that not correct?
You mean whether they actually got notice that the minute entry had been entered?
Yeah, that was what I understood him to be saying, was that the parties were not notified of that. Is that right, or is that correct?
And I'll have to, I will, well, and now you have to say, what didn't they get notice of? I mean, clearly they had noticed that the trial was over and the judge had rendered his decision and that he had no intention of taking any further action. They clearly had notice of that because he announced it on the record.
Right, but if the rule hinges on the minute entry, is he right that the parties were not notified about the minute entry?
I do not know the answer to that. And maybe that would be a question for supplemental briefing, because I believe that everyone who is a party to the case is electronically notified when things are filed on the docket. And I understand that Mr. Richards wasn't there, but the parties, the appellants in this case had counsel. And I believe that counsel of record does get electronic notice of things that are entered on the docket.
Is that true of private, of documents and orders that are private?
I believe so, because the privacy is that people who are not parties to the case can't get access to them. The privacy isn't to protect it from people who are parties to the case. And the reason that Mr. Richards may have had difficulty getting access to things is that he was not a party to the case. And one of the issues is
his clients certainly were.
His clients certainly were, and you know, I don't know, and maybe by the time that this actually became an issue for them, which was a year later or a year and a half later, perhaps by that time the case has been closed and sealed and nobody outside or even inside can have access to it anymore. Okay. But that's not the question. The question is on the day the clerk entered, the minute order was filed and the clerk entered the minute order, was it, what did the parties get notice of that? And if the court will excuse me just 1 second, I want to look at something. Okay, yeah, I was just looking on the docket. It is marked private. But again, I don't think, and again, maybe this is an issue for supplemental briefing, but if it's important, but I don't think that those entries and what is recorded on the docket and what is entered on the docket is kept private from the parties.
Let's just indulge his interpretation just for a minute for purposes of argument. Let's just suppose he's right that the parties were not given notice of the entry of the minute entry. if I'm understanding you correctly, you're saying that it's a mechanical rule regardless of whether they get notice. And his response to that seems to be, well, that would be unconstitutional to terminate my appellate rights based on the entry of an order where I wasn't given notice of that. How could it be constitutional to terminate his appellate rights if he wasn't at least given notice that the clock had started running? How could that be? How could that be constitutional?
Because in fact they did have notice that the decision had been made, and that it
Right,
followed.
but if the clock starts running off of the minute entry, how could it be constitutional if he's not given notice of the minute entry, if his client's not given notice of the minute entry?
Because it's court practice that when the court enters a minute order, it's entered on the docket. And everybody knows that. And so they are on notice that if a minute order is issued, it will be on the docket. And it is also the parties to the case are on notice that when a court makes a decision or when a court makes any kind of ruling, they enter that on the docket. You look at every docket I've ever seen, everything that happened in that court, the minute orders, the continuances, the hearing dates, the filing of the documents, everything the court does and everything the parties does is entered on the docket. And everybody knows that.
So if I understand correctly, you would then argue that if perhaps the court on its own and not in open court had entered something that triggered this and didn't provide notice, that perhaps there'd be an issue. But where the court enters an order in open court, the parties are present, everyone hears it, he announces his finality, but just by nature of practice, the parties understand or should understand that something will be entered in the docket to reflect that. And that's why they have notice, even if something separate isn't sent to them. Do I have that? Am I understanding correctly?
Correct. That's a very nice summary of what I was attempting to say. Thank you. Yes.
Can I ask you a different question about this? You filed the motion to dismiss for lack of appellate jurisdiction, and we ruled on it. How often do you get to raise this argument? I mean, I understand that an appellate court can raise appellate jurisdiction whenever it wants to, but is appellate jurisdiction subject to ordinary preclusion doctrines, law of the case, res judicata, and so forth? Or is it just a unique doctrine that you get to raise as often as you want?
I think the case law says pretty definitively that the issue of lack of jurisdiction can be raised at any point in time. And the case law also says definitively that the decision must be made to that the court must determine its jurisdictional authority before it can rule on the merits.
I understand that it can be raised at any time, but I guess what I'm wondering about is the next sequential step. If it has been raised and if it has been ruled on, why doesn't that settle the question? Why does the party get to raise it again if it doesn't like the outcome, or again or so forth? Why don't we just apply law of the case here and say, well, we already looked at this, we answered it, we're done on this question? Why isn't that the answer here?
Because I think that and I think that if it were any other issue, that might be the answer. But jurisdiction is so important that if the court doesn't have it, you can't enter you can't rule on the merits.
So in theory, if we issued a decision today, again reaffirming our previous position that there was appellate jurisdiction, but we remanded on some other basis, suppose for entry of more specific findings, it comes back up on appeal, your position would be that you could raise the appellate jurisdiction a third time and ask us to consider it again?
No, at that point I could not, because it would have been a final decision of the Court of Appeals issued by the entire panel. And quite frankly, if you were to issue such a decision, my next step will be to ask for the Supreme Court to take certiorari, to file a petition for certiorari in the Supreme Court.
So your position, just to clarify, so your position is that the reason there's no sort of preclusive effect from the earlier ruling we had on it was that it was a single judge as opposed to a full panel?
Correct. There has not been a final decision of the law of the case requires a final decision of the adjudicatory authority, and there has not been a final decision of the Court of Appeals in this appeal. There's been a decision signed by one judge that said we haven't denying our motion to dismiss. And again, if it had been any other issue other than a jurisdictional issue, we probably wouldn't have raised it again. But I think that this rule is so clear and the intent of the intent of the rule, both leading into the creation of the rule by the request of the Utah Supreme Court to the Rules Committee to take a look at this, and the adoption of the 150-day rule, and then the decision in Griffin versus Snow, Christensen, and Martineau that says that this rule is supposed to be applied mechanically. It means what it says. When the court issues a decision, you have a couple of alternatives. You can either get a written order, in which case the appeals opinion starts from 30 days of the written order, or you can, or at the end of 150 days, if there is no written order, the judgment is deemed entered. And the parties certainly knew that 150 days had passed from the end of
What happens if in the middle of that 150-day period, say at day 75 or day 80, one of the parties notifies everybody else that it's preparing the order and it just hasn't gotten there? I mean, he's saying that that's what happened.
They better get it done within 150 days.
So if they file something, they say on the record at day 100, hey, I'm working on the order, and they just don't get to it. Your argument is that at the 150-day mark.
Correct. The rule's very clear about what sort of things toll the running of the timing period to file a notice of appeal. And I was involved in another case in front of the Supreme Court where they were arguing that the time to file an appeal was told by the filing of a Rule 59 motion. The Rule 59 motion had been filed 5 minutes after midnight on the 31st, what was then the 31st, now would have been the 29th day. And the Supreme Court threw the appeal out. They said that wasn't timely. And the Rule 59 motion wasn't timely, and only a timely filed Rule 59 motion told the time to file an appeal. So the calculation of the periods of time in which to file an appeal are applied mechanically. They're applied without deference to the fact that somebody might be trying to do something. You've either done it or you haven't done it. Plus which, it's not my client's responsibility to prepare that order. And he was not preparing the order, or he was not attempting to prepare the order for the purposes of filing an appeal. He wasn't going to appeal, he won. He was preparing the order because in a different case, yes.
Can I take you to the merits, unless the other judges have?
Okay.
We're close. If I understood from the briefing, he's arguing that the legal error here has to do with the prima facie case component of it. And if I understood your brief correctly, you're saying that that's not at all what the judge did, that the judge really moved to the second part of this and just dismissed the case as a whole. Did I understand that right?
Yes, I think what the judge did is the judge found, it's not entirely clear whether the judge found that they had made a prima facie case, but that it had been rebutted by other evidence. But I think it is clear that the court found that on the whole, the parents, the mother and the stepfather had not established a clear and convincing case of abandonment. And I think that the exact argument that Mr. Richards was making has all been addressed by the Utah Supreme Court in the 438 Main Street versus Easy Heat case that is used in every comes up all the time in appellate cases. And in that case, they've said under Rule 41, the court can dismiss the case at the close of the plaintiff's evidence if the plaintiffs have failed to make a prima facie case, or the court is otherwise unconvinced that they have carried their burden.
Let me ask you another question, and I apologize if this is basic. I'm still grappling with this area of law. The 6-month component that he keeps referencing, if I understood it correctly from the briefing, that has to do with the prima facie case part of the rule, but it doesn't kick in if what the court was really doing was evaluating the case as a whole. Did I understand that correctly, or do I have that wrong?
Correct. And part of the reason the rule works the way it does, and I think it's explained quite clearly in the Supreme Court case in re TE that we 2011 case that we cited in the brief. What the rule does is it has the prima facie case. If these things have happened, then there's a prima facie case of neglect or abandonment. And those things are that bar is really low.
And that's where the 6-month no contact provision kicks in. So if I've got it right, your position is that it doesn't matter. Much of what he's arguing about these 6-month periods, your position is that just legally doesn't matter.
Well,
right?
Not so much that it doesn't matter, but that it's not dispositive. Because if you look at 78A-5 I always get the numbers wrong. If you look at the grounds, is in 507. But then if you look at the next section, 508, that explains how you're supposed to apply that. And then if you look at cases that have interpreted like TE, they say, look, it's not enough to just establish that there hasn't been any contact. You must establish a two-part test.
Yeah.
One is that the
conscious disregard.
Pardon?
Yeah.
Okay, the two-part test. One is that the first part is that the failure to communicate was evidence as a conscious disregard of the rights and obligations as a parent. And then the second half was that that leads to the destruction of the relationship. And in this particular case, I think the findings that were entered by the judge demonstrates that that the parents did not, that the mother and the stepfather did not make a prima facie, did not carry their burden on either half of that. They did not establish that my client was in conscious disregard of his obligations. He was doing everything he could think of. He was sending emails. He sent his wife, and as soon as he sent his wife, they got a restraining order against her, which also prevented the children from ever coming to visit him because there was a restraining order against the wife. He filed a paternity action in Texas where he thought that there was jurisdiction, and then it turns out that Texas didn't have jurisdiction because she'd moved to Utah. This is not somebody who just stepped away and said, I don't want to have anything to do with my kids. There are plenty of, yes.
I know we're running out of time, so can I just ask you a pointed question? He just argued earlier this morning, that the court's findings, there's a bit of a disconnect. The court's talking about, she moved around a lot, that made it difficult for him to maintain contact, but that actually during those moves, there was contact. It was at other times there wasn't contact. I would just like you to respond to that particular argument.
Yes, because the test isn't whether there was contact for 6 months or not contact for 6 months, or contact in this period or not contact in this period. The test is whether the failure and any failure to make contact exhibits a conscious disregard of the rights and obligations. And in this regard, this court has to defer to the decision to the fact finding of the district court. The district court heard the mother, he heard the father. He listened to a great deal of evidence. He saw all of the email messages back and forth, the Facebook pages, the communication, and it was his conclusion after analyzing all this evidence that the father is not someone who has exhibited a conscious disregard for his rights and obligations. And he also specifically found that it wasn't anything the father did that led to the destruction of the relationship. He found that part of the reason that the father did not have a relationship with his children is because the mother had acted as a gatekeeper. And that is a relevant consideration in the cases that we have cited, that if the mother is interfering and preventing the father from establishing the relationship, then the destruction of the relationship is not on him. And one final point is that those two parts, conscious disregard and that leads to the destruction of the relationship, has to be established by clear and convincing evidence. There's no doubt about that. And one of the things that the appellant's arguments are pretty short on is acknowledging that obligation, that the evidence must be clear and convincing. And the judge said, I don't find that they have made a clear and convincing case. I find that there is plenty of facts in here to show that the father was trying to have a relationship. He was trying to have contact. He was doing what he could, and he was stymied in his ability to have the kind of relationship he wanted by the acts of the mother. And so those are conclusions, factual findings of the trial court that are supported by the evidence, and to which this court must defer those factual findings. And the clear and convincing burden is an important one. We're talking about termination of parental rights. Now, I often think in cases like this, and I've been involved in several cases like this where there was a step parent who wanted to adopt, that it is a shame that we do not have rules and statutes in this case that allow for there to be two fathers, two legally recognized parents. It's a shame because I think everybody in this case agrees that the stepfather is a good guy and that the children's life has been enhanced by having him in it. But the question isn't whether the stepfather is fit. The question is whether the father, who is also entitled to have a relationship with his children, has forfeited that right by being neglectful or abandoning them or making less than token efforts. And I think that the evidence in the case more than adequately supports the trial court's ruling that he did not act in conscious disregard, and that his actions did not, or at least did not alone, lead to the destruction of the relationship. And if there is a balancing of evidence to be made, if there's evidence on one side and the evidence on the other side, the Supreme Court has quite recently this year clarified that clear and convincing means clear and convincing, and that the Court of Appeals must review any challenge to a decision involving the termination of parental rights through that prism.
We have gone way past, which is perfectly appropriate and necessary, but you're out of time, Ms. Frommer, and unless you have just, 3 concluding words, I'm gonna.
My brief concluding words are that I do not believe that this court has appellate jurisdiction. I think Rule 58A(e)(2)(b) makes that perfectly clear. I think that the Supreme Court decision in Griffin v. Snow, Christensen, and Martineau makes it clear that that rule is supposed to be applied mechanically. There is no question that the appellants in this case had noticed that the court had issued its final decision. And there was also no question that it was something like 400 and some odd days before they actually filed their notice of appeal. On the merits, they simply failed to carry their burden of clear and convincing evidence supporting their allegations of neglect. And the court properly, and in fact, in more detail and more thoroughly and completely than many decisions, articulated its reasoning for that decision. And this court must defer to those findings of fact.
Thank you. Thank you very much for your arguments. Mr. Richards?
Thank you. I'll hurry through this.
Can I start you somewhere in particular? I apologize to just jump in. It seems to me that one of the legal hinge points that we have to figure out is what it is that we're reviewing. And you've cast this as a review of the trial court's determination that there was not a prima facie case presented. And the other side has presented this, it has said, no, the trial court essentially jumped past that, decided that it was, quote, not persuaded by the evidence. And that seems to matter. I mean, that gets at the 6-month question that I was asking you earlier. Convince me that what the trial court was doing was saying there was not a prima facie case as opposed to just looking at the case as a whole. I'm stuck on that.
It's primarily a challenge to the conclusions of law reached by the trial court. That's the main issue, because the prima facie evidence of abandonment, I mean, it's a disconnect, right? Because in most civil cases, you look at a prima facie showing as on the face of the evidence presented, can the evidence support the relief that's being sought, right? In the Juvenile Court Act, in the termination statute, abandonment is described as a prima facie issue for that 6-month period. And so that's where I think there's the disconnect. But our challenge is to the trial court's conclusions of law, because I mean, we extrapolate on what we think the trial court did. I mean, Ms. Frommer, I think, did a good job of creating the trial court's conclusions of law for it. But the evidence that's presented in that case was not applied to the law. I mean, that's
Do I have it correct procedurally that as part of the opening salvo of case, the father and his sister testified?
no. So
I thought I read that in the briefing.
the father was called as an adverse witness.
Okay,
right?
so he did testify.
He did testify.
And his sister testified.
I don't think. Yes, right. Yes.
So,
she was the last
so
witness.
doesn't that suggest that this had moved beyond prima facie case from mother and stepfather? I mean, if you've got arguably the two central witnesses for the other side, why isn't the cleaner way to look at this is that the court had just done a whole case analysis under that second part of Rule 52?
Because the trial court's conclusions don't. I mean, you know, we go through this the second part of an abandonment analysis that the parent has consciously disregarded his or her parental obligations, that the conduct has led to the destruction of the parent-child relationship. You won't find that language in any of the oral findings made by the district court. Nothing. That there is no analysis of that. We are all just sitting here extrapolating on the evidence and what the trial court should have done. I mean, that's essentially what Ms. Frommer's argument is the trial court, there was enough evidence and it supports an abandonment claim, except the trial court doesn't even address that, doesn't even properly analyze what an abandonment claim is. And so that's the problem with the findings.
But doesn't the court's focus on how he believed mother and stepfather may have prevented father's access, doesn't that suggest he understood those other prongs and that's what he was looking at? I mean, I'm trying to figure out how else we look at that. That seems to be the question that he's asking, or at least he's analyzing, is whether or not this was due to father's efforts or if he was impeded in some way, which gets to those issues that come after the prima facie case. So why is it wrong for us to look at his order that way, even if he doesn't use the buzzwords from the statute?
Well, I mean, those words are essential. I mean, that's how you prove a claim. And so I mean, my view of the trial court's findings is he's treating this like a divorce case or a custody case, because he puts fault on both sides. He says, mom moved around a lot. Could dad have done more? Yes, he could have done more. And then essentially says there is no abandonment. I mean, that's my review of what the trial court did in this case.
Well, it goes beyond that. I mean, he has that line that Ms. Frommer referenced about the mother being the gatekeeper and engaging in obstructionist, I don't have the exact phrase in front of me, but something to the effect of obstructionist behavior, which seems to move beyond what you just said, doesn't it?
Well, I think that I don't recall exactly him saying gatekeeper or obstructionist, but clearly he did indicate that he felt that father's efforts were stymied by the mother. But, you know, again, I think that's against the clear weight of the evidence. I really do. When I read through, I mean, there's a lot of communication from mom to dad, especially during those times that she's.
Well, there's a restraining order.
Well, that's because his wife came up and threatened to take the kids.
Sure, but then in the responsive brief, they've quoted, I believe it was an email, it may have been a text, in which mom says to father that because of the restraining order, she doesn't see how the kids can go to the house.
Well, and actually that restraining order, and I don't know if it was presented as evidence, but that restraining order allowed for contact. It allowed for contact with dad, and I don't think it pertains to the residence. But even if that were true, I mean, there is direct case law on this question on dad doesn't have contact with his kids because there's a protective order in place. It doesn't matter. I mean, he has a protective order. Dad's wife has a restraining order. That in and of itself is more important than that's stopping his ability to have contact with the kids. It's not mom got a restraining order, how dare she? It's dad and his wife are acting inappropriately, and the court entered a restraining order against them. I mean, that's the bigger concern, I think. And you know, I also take a lot of issue with dad filing a custody case in Texas where the kids haven't lived in years, and finding that is supportive of dad not disregarding his obligations to the children. Children clearly at that time were living in Utah. Mom had not moved around, and this family had a long history.
I'm not sure how you could do that, though. On page 36 of your brief, you made the point that while mom was moving around, that the father, I'm quoting you, quote, could easily have filed a custody action in any of these states. So I thought your point in your brief was that that's what he should have been doing all along, was filing custody actions in the various states that she was moving to.
Well, I mean, yes, he should have, not in Texas where the kids don't live. I mean, I don't look at
but when you say any of these states, okay, I see your point, right, okay.
I just don't see that as a good faith effort to maintain contact by filing. I mean, if he would have talked to any lawyer, custody lawyer, they would have said, well, under the UCCJEA, you can't file, you have to file it where the kids live for that specific period of time. Or if it was early on, like Dad says, Mom took off to Washington, she was supposed to come back, he could have filed in Texas. I mean, the kids hadn't been gone for that long at that point, but he didn't. He filed in Texas years later.
Your point isn't that it would have been improper to have ever done it in Texas. Your point is that it was improper to have done it in Texas at the time that he did it.
Yes.
And that's why there's a conscious disregard, because he was off on the mechanics of it.
Well, he filed in the wrong state. I mean, and I don't think that you can, I mean, it's not my client's fault that he doesn't understand where he can file a petition to get custody or parent time. Anyway, I'm out of time. I have more I can say, but I know the court has a schedule. The only thing I'll end with is that the 150-day rule is unconstitutional. Number one, I do think it's been addressed, thoroughly in this case. There was briefing on that exact question, and the court denied it after looking at that thorough briefing. And it's not everybody knows. Once an oral decision is made, everybody doesn't just know that the clerk has entered a decision. There is actually, in every case now that we are all doing e-filing in district court, there is a certificate of notification, of electronic notification that's issued every single time something is noticed from the e-filing system. There's no evidence in this case that was ever done. There's no return of service, no return of electronic notification, which is done in every single case that you get notice on. And for my purposes, I did enter an appearance, and I still had to file a motion to unseal the hearing because I couldn't get documents. So it's not that I wasn't a party. I represented a party and still couldn't get it. But again, what I'll end with is this is an attack of the trial court's legal conclusions, which the court looks to for reviews for correctness. And the trial, I don't think anyone with a straight face that reviews termination cases can say that the trial court did a proper abandonment analysis in this case. Thank you very much.
Thank you, Mr. Richards, and Ms. Frommer, if you would just come back quickly. You are able. Thank you. We appreciate your arguments today. They were very, very helpful, and thank you for spending the time and explaining things to us and answering our questions. It was great, and we appreciate it. We will take this matter under advisement and render a written decision as quickly as we possibly can. And thank you again for your time.